one of the things that I want to share with you is something new and different that we've done in the ERISA healthcare subrogation resolution universe. And for a lot of times, lawyers have simply, when met with a self-funded ERISA qualified plan who's asserting a claim for subrogation reimbursement, they've just simply said, oh, okay, well, it's self-funded and ERISA qualified. There's not really much I can do. And what we are doing now in that space is really attacking that presumption because there are some things you can do. This is a particular case that we have been involved in, that we've got some recent success, and it involves a self-funded ERISA qualified plan that falls in the category of what we call a VEBA plan. It's a voluntary employee benefit plan. And it was set up about 12 years ago. 13 years ago, Goodyear started rating its pension plans. They started rating the retirees, Goodyear, Dunlap. These were steelworker union members. And as a result of that, a big batch of litigation broke out. And so there was a settlement about 12 years ago in the Reddington case. And basically, the union and the retirees sued Goodyear. They reached a settlement that was overseen by a federal court. The Department of Labor was involved. And as part of the terms of the settlement, Goodyear agreed to pay $1 billion to a 9-person committee that would then provide these health benefits for Goodyear and Dunlap retirees presently and for folks who would come to retire in the future. The reason they set it up as a VEBA trust is so that Goodyear could dollar for dollar take immediately the tax benefit of the $1 billion they used to pre-fund it. In addition, the health plan could invest the money and not have to pay tax on any gains they made in the market. When you talk about being innovative and when you talk about taking a look, there's always a reason to take a second look at an issue that everybody just thinks is a pain. No one wants to understand ERISA subrogation reimbursement. It's been difficult. Historically, it has been very, very difficult for plaintiffs to be successful. But I do believe the lawyer has a good faith obligation, and best practices are when you're dealing with large liens, just taking the word for it that they're a self-funded ERISA qualified plan is not enough. There needs to be an added level of inquiry, especially when you're talking about anything 6 figures or more that they're asking to be paid. I think lawyers have an obligation not to dissipate those funds improperly. At the same time, they've got an obligation under 1.15 to make sure that they recognize if there's a valid claim. And it's a tough call, and it's only getting tougher. And whether it be someone like my firm or there are a lot of other firms who do it, if maximizing the client's net recovery is the value, and the plaintiff's lawyer does that by increasing the amount recovered from the tortfeasor, what we do is maximize that by decreasing the amount of that settlement that goes back to the health plan. And at the end of the day, that's the goal, to maximize when that client gets up from the table, how much they walk away with, to make sure that those funds can last them as long as they can. And I think this is something that over the past decade, I've seen more and more lawyers just sort of roll their eyes, or there's no way around it, or they don't want to dig into it. But I think that this is such a rich area and potential for litigation.